The courtroom smelled like old wood and someone else's perfume. I noticed that the moment I walked in, 9:02 on a Monday morning, the kind of gray Atlanta day where the sky can't decide whether to rain or just threaten to. The fluorescent lights overhead had that particular coldness that makes everyone look a little sicker than they are. The kind of light that doesn't flatter anyone. The kind of light that doesn't lie, either. I sat down at the table on the left side of the room and placed my purse carefully on the floor beside my chair. Not because I was afraid someone would take it, but because I needed something to do with my hands that wasn't gripping the edge of the table. Across the room, Stuart Pratt was already moving. He was one of those men who never quite stood still, always adjusting his cufflinks, always shifting his weight, always reminding the room that he was there and that he was expensive. His suit was charcoal gray, perfectly pressed, the kind that costs more than most people's car payments. He had the practiced ease of a man who had walked into courtrooms for 30 years and expected to walk out of every single one of them having won. I watched him without turning my head. You learn that after 30 years of teaching 5th grade. You learn to see everything without appearing to look at anything. Vanessa was already seated at the table on the right. Derek sat beside her. My son, 34 years old, and he was sitting on the other side of this room from me. He had Robert's hands. I noticed that again, the way I always noticed it, the way I had been noticing it since Derek was about 9 years old, and I looked down one afternoon while he was doing homework and thought, those are his father's hands. Wide across the knuckles, slightly square at the fingertips. Robert's hands had built things, fixed things, held my face on the worst nights and the best ones. Derek was using those hands to study the surface of the table in front of him. Vanessa sat perfectly straight, navy blue suit, hair pulled back, pearl earrings, not too large, not too small, exactly calibrated. She was staring at the front of the room with the focused expression of someone who has already decided how this day ends. In 31 years of living, she had developed the ability to look composed the way some people develop the ability to play piano, through practice, through repetition, through a commitment to never letting anyone see what was happening underneath. She didn't look at me, not once from the moment I walked in. I want you to understand something about that. When you have done something wrong, truly wrong, not a mistake, not an accident, but something you chose, there is a specific way you avoid the eyes of the person you've wronged. It's different from ordinary inattention. It has a quality to it, a deliberateness, like a building that has been designed to have no windows on one particular side. A person with a conscience, even a guilty one, will look at you eventually, even just once, even just for a second. Vanessa never looked at me. That told me everything I needed to know about what kind of person she was. And it told me everything I needed to know about the fight ahead. My attorney, Calvin Reeves, settled into the chair beside mine and opened his folder with the quiet efficiency of a man who had done this 1,000 times. He was 55, with close-cropped silver hair and reading glasses he was always either putting on or taking off. His office was small and his furniture was unremarkable, but I had once watched him reduce a hostile witness to near tears using nothing but a follow-up question and a long pause. He didn't need an expensive suit. He needed to be smarter than the other person in the room. And he was. He leaned slightly toward me. You doing all right? I'm fine, I said. He nodded once like he believed me and went back to his papers. I wasn't fine, of course. I hadn't been fine in 14 months, since the February morning I stood in my kitchen holding a letter from Wells Fargo and felt the floor of my life drop away. But I had learned in those 14 months the difference between fine and ready. I wasn't fine, but I was ready. Judge Patricia Owens entered at 9:08 and the room rose. She was 58 years old, with natural gray locks pulled back from her face and eyes that had seen, I suspected, every variety of human foolishness and cruelty that the legal system could produce. She moved with the authority of a woman who had not spent 1 minute of the last 20 years wondering whether she belonged in the room she was standing in. She sat. We sat. I folded my hands on the table in front of me. They think I am a confused old woman, I thought. They have been thinking that for over a year. They built an entire case on that idea. They are about to find out what I've been building. I wasn't afraid anymore, because I had something they didn't expect. I taught 5th grade at King Elementary School in Atlanta for 28 years. I want you to sit with that number for a moment. 28 years. That is roughly 4,000 children who passed through my classroom. 4,000 10-year-olds who came in every September not yet knowing how to write a proper paragraph. or explain why the Civil War happened, or calculate what 20% of $60 was, and who left in June knowing all of those things, plus a few others I slipped in when they weren't paying attention. Things like, your opinion matters, but you have to be able to back it up. And the most important word in the English language might be why. And if someone tells you that you're wrong and you know you're right, make them prove it. I didn't teach 5th grade because it was the easiest option. Lord knows it wasn't. I taught it because it's the age when children start to understand that the world is larger and more complicated than they thought, and more unfair than they were told, and I wanted to be one of the people who helped them figure out how to be brave about that. On my desk for 28 years, I kept a small ceramic bowl filled with peppermint candies. Not for the students, though they always tried, for the parents. Because Robert told me, early in my career, that the parents were often more frightened than the kids, and frightened people needed something to do with their hands. Give them something sweet, he said, and they'll trust you a little more. Robert Harmon, my husband of 42 years, a civil engineer who spent 35 years with the same firm and never once complained about it, because he believed that showing up and doing the work well was its own kind of dignity. He was not a flashy man. He didn't need to be the loudest voice in the room. He was the kind of man who, when he said something, people stopped and listened, not because he demanded it, but because he had earned it. We were not wealthy by any dramatic standard. We didn't have vacation homes or luxury cars or country club memberships. What we had was discipline, 40 years of careful saving, of living within our means, of Robert coming home from work and sitting at the kitchen table with his yellow legal pad and working through the numbers. By the time he was diagnosed, we had a home in Decatur with no mortgage, a portfolio of modest investments, and retirement accounts that added up, together, to approximately $1.8 million. Robert built that. He built it the slow, quiet way, the way that doesn't make good stories at dinner parties, but that produces something real, something that was supposed to last. He was diagnosed with pancreatic cancer in March. He died in November. 8 months. That's what we got between the diagnosis and the end. 8 months during which I learned, in ways I would not wish on anyone, exactly what it means to love someone all the way to the finish line. Derek brought Vanessa home for the first time in October of 2019. I had spoken to her on the phone twice before that. Brief calls, cordial, the kind of conversation you have when you're both still deciding what to make of each other. When I finally saw her in person, my first thought was that she was exactly as I'd imagined. Polished, precise, the kind of woman who moved through a room like she'd already mapped it. She brought a peach cobbler, not store-bought, homemade, in a ceramic dish, still faintly warm, with a crust that had the particular golden brown color that only comes from actually knowing what you're doing in a kitchen. She set it on my counter and said, almost shyly, "Derek mentioned it was Mr. Harmon's favorite." I looked at her. Then I looked at my son, who was grinning with the specific pride of a man who has, against all odds, done something right. "How did you know to make it?" I asked. "I asked him," she said simply. "I wanted to make a good impression. I thought at the time that this was the loveliest thing. A young woman who cared enough to ask, to prepare, to show up with something warm." Robert ate 2 helpings that night and told her she was welcome in our house any time she pleased, and I believed, watching him say it, that he meant it completely. I believed a great many things about Vanessa in those early years, that she was warm, that she was genuine, that her affection for Robert and me was real. She called me Mom Julia, not Mom, which might have felt presumptuous, and not Mrs. Harmon, which would have felt cold, but Mom Julia, which managed to be both intimate and carefully boundaried at the same time. I thought it was charming. They married in 2020. A small ceremony because of the pandemic, and for 2 years things were, or seemed to be, good. The first moment I didn't trust was small enough that I talked myself out of it almost immediately. It was 2021. Robert had been having some health issues. Nothing we knew was serious yet, just fatigue, some weight loss, the kinds of things you attribute to age and tell yourself aren't worth worrying about. Vanessa came by one Sunday afternoon and mentioned in passing that she'd been looking at some tools for streamlining estate planning for aging parents, her words, and that she'd love to help us organize our accounts so everything is in order. I felt something shift in my chest, just slightly, just for a second. Robert said, "That's very thoughtful of you, sweetheart." And the conversation moved on, and I told myself I was being uncharitable to a young woman who was only trying to help. I was wrong to tell myself that, but I didn't know it yet. The morning everything changed, Valentine's Day, February 14th. I remember thinking that morning that I should do something to mark the occasion. The first Valentine's Day without Robert. Maybe drive out to the cemetery. Maybe just sit in his chair in the study for a while, the way I sometimes did when I needed to feel close to him. Instead, I was standing at the kitchen counter when the mail arrived, and there was a letter from Wells Fargo in the pile, and I opened it the way you open any letter from your bank, with mild interest and no particular expectation. I read the first paragraph 3 times. Then I set the letter down on the counter and stood very still for a moment, the way you stand when the ground has moved under your feet and you're not yet sure it's stopped moving. The letter informed me that the joint checking account held by Robert Allen Harmon and Julia May Harmon had been transferred in full to the sole management of Vanessa Lee Harmon, acting under a durable power of attorney signed by Robert Allen Harmon on October 9th. The balance that had been transferred, $340,000. I picked the letter back up, read it again, set it down again. Then I went to the kitchen drawer where I kept important papers. The practical drawer, Robert called it. The one with the passports and the insurance cards and the spare house key. And I found our bank statements from the last 18 months, and I started going through them, carefully, methodically, the way Robert had always done it, with a yellow legal pad beside me. What I found over the next 4 hours, sitting at that kitchen table with my reading glasses and my legal pad and 3 cups of coffee that went cold before I drank them. Vanessa had been named co-owner on 3 of our investment accounts, added sometime in the spring of the previous year, while Robert was undergoing his initial rounds of treatment. She had refinanced our home in Decatur using a power of attorney, the same document, taking out $280,000 against the equity Robert and I had spent decades building. She had, in total, positioned herself to control or access approximately $890,000 of the estate Robert had spent his entire working life building. And she had done all of it while I sat beside my husband's bed and held his hand and counted his breaths. I put my pen down. I looked at the legal pad in front of me. Then I looked at the power of attorney document I'd printed from the bank's secure portal. I had watched Robert Harmon sign his name thousands of times in 42 years. Birthday cards, Christmas cards, the deed to our house, Derek's school permission slips, love notes left on the bathroom mirror. I knew his signature the way I knew his voice, the way I knew the sound of his particular cough, the way I knew exactly how he took his coffee. The signature on that document was not his. I was sure of it the moment I looked at it. Not suspicious, sure. The way you are sure of things you know in your bones. I picked up the phone and called Derek. Why I walked into Calvin Reeves' office. The phone call lasted 4 minutes. Derek sounded strange. Not surprised exactly, but not quite right either. The way a person sounds when they have been told what to say and are trying to remember it accurately. He said that his father had been very concerned about my ability to manage things on my own. He said that Vanessa had only been trying to help. He said that the power of attorney was signed when Robert was still of sound mind and that everything had been done properly and legally. He used the word properly twice. I noticed that. I said, Derek, that is not your father's signature on that document. There was a pause. Then, Mom? You've been through a lot. Maybe you should talk to someone. I hung up the phone. The following Tuesday, I asked Vanessa to meet me for coffee. She agreed readily. Too readily, perhaps, but I told myself I was being paranoid. She arrived at the coffee shop on time, dressed beautifully, carrying a manila folder fat with papers. She spread documents across the table with the practiced efficiency of someone making a presentation, explaining each one in a clear, patient voice. The voice, I realized, of someone who has rehearsed this. Robert was worried about you managing things alone, Mom Julia. This was his way of making sure you'd be taken care of. I looked at her across the table. At this woman I had welcomed into my home, fed from my kitchen, called my daughter-in-law for 5 years. I asked her one question. Can I see the original documents, Vanessa? Not copies. The originals. Something happened in her eyes. It lasted less than 2 seconds, and then it was gone, replaced immediately by that smooth, composed expression. She said the originals were being held at the attorney's office for safekeeping. 2 seconds. That was all it took. The next morning, I drove to a small office on Auburn Avenue and sat down across from a man named Calvin Reeves. I told him everything. I put the bank statements and the letter and my legal pad on his desk. He read for a long time without saying anything. Then he looked up at me over his glasses. "Mrs. Harmon," he said, "how much time do you have?" "As much as it takes," I said. He nodded slowly. "Then let's get to work." Calvin Reeves had been practicing law for 27 years, and he had a gift I didn't fully appreciate until I watched him work. He was not easily surprised, but he was very, very good at surprising other people. The first thing he told me, at our second meeting, was that the forgery case was strong but not simple. Robert was gone, which meant we couldn't put him on the stand. The power of attorney had been notarized by a notary who, Calvin suspected, had been paid to ask fewer questions than she should have. And Vanessa had been careful. She'd built her paper trail over months, not days, which meant it would take time to unravel. The second thing he told me was worse. He slid a document across the desk. I picked it up. It was a psychological evaluation report. My name was at the top. The date was from 16 months earlier, nearly 6 months before Robert died. "She had you evaluated," Calvin said. "You didn't know about it." I stared at the paper. The evaluation had been conducted by a Dr. Leonard Ferris, a private psychiatrist I had never met, never consented to see, never had any contact with. According to the report, he had assessed me through what was described as an indirect observational consultation, which Calvin explained with barely contained disgust was a legal way of saying that someone had watched me and reported on my behavior without my knowledge. The conclusion of this report: subject shows early signs of cognitive decline, difficulty with complex financial reasoning, short-term memory inconsistencies noted. "She was building a case," I said. It wasn't a question. "She was building a case," Calvin confirmed. "If you challenged the power of attorney, she was going to argue that you lacked the mental competency to bring a legal claim. She wasn't just taking the money, Julia. She was making sure you couldn't take it back." I sat with that for a moment. The full shape of it, the planning it required, the patience, the contempt. "When did she start?" I asked. Calvin thought about it. "Based on the timeline I've put together, probably around the same time Robert got his diagnosis, when she knew the estate would be in play. The same time Robert got his diagnosis. While I was sitting in doctors' offices with my husband, holding his hand and taking notes on treatment options, Vanessa had been sitting somewhere else, building a case for why I shouldn't be trusted to hold anything at all. I pressed my hands flat on the desk, felt the cool solidity of it. "What do we do?" I asked. "We go to court," Calvin said, "and we make sure we have more than they expect." 3 days later, Vanessa's attorneys, a firm called Whitfield and Pratt, which I noted with grim interest shared her maiden name, sent over a settlement offer through a third-party mediator. $120,000, a signed agreement that I would pursue no further legal action. Calvin brought it to me and said nothing, just watched my face. I looked at the number. $120,000 out of $890,000. 14 cents on the dollar. Enough to seem generous if you squinted and turned your head sideways. Enough perhaps to seem like the reasonable choice for a confused elderly woman who just wanted this to be over. I pushed the paper back across Calvin's desk. "No," I said. Calvin smiled. It was the first time I'd seen him smile. "I was hoping you'd say that." The hardest part of those weeks wasn't the legal preparation. It was everything that happened around it. Derek called twice a week, every week, without fail. The calls had a quality I recognized from my teaching years, the quality of a child reciting something they'd memorized. "Mom, this is going to destroy the family. Mom, is this really what Dad would have wanted? Mom, Vanessa is not a bad person. She was trying to help. Please just let it go." I listened to every call. I answered his questions. I never raised my voice. But I noticed that every argument he made was phrased in Vanessa's cadences. He was using her sentences. She had given them to him, and he was delivering them, faithfully, because he loved her and because he didn't yet know the full truth of what she had done. That was the cruelest part of what Vanessa had built. She hadn't just stolen from me. She had recruited my son, without his full knowledge, as a delivery mechanism for her campaign. She had made him complicit without making him culpable. She had used his love for me as a tool to reach me, and his love for her as a reason to keep him from looking too closely at what she was actually doing. The community talk was harder to bear than I expected. I heard through Beverly, my closest friend since our Spelman days, 40 years of friendship worn smooth as river stones, that there were whispers, that Julia Harmon was suing her own son, that grief had made her unreasonable, that there must be something to the concerns about her mind, because why else would Robert have made those changes to the accounts? I did not defend myself publicly. Calvin had advised against it, and besides, I had spent 28 years teaching children that the most powerful response to someone who questions your competence is not an argument. It is evidence. I was building evidence. One night, about 3 weeks before the trial date, I couldn't sleep. I lay in the dark in the bedroom Robert and I had shared for 30 years, listening to the house settle around me, and I thought about all the ways this could go wrong. The forged documents were clear to me, but would they be clear to a jury? The evaluation report was ethically questionable, but would a jury care about legal ethics? Vanessa was poised and articulate and capable of generating sympathy. I was a 60-year-old black woman suing her own daughter-in-law, and I knew, because I had lived 60 years in this country, what assumptions might be made about which of us was the difficult one. At 2 a.m, I called Beverly. She picked up on the second ring, because that is who Beverly Oakes is. The person who picks up on the second ring at 2 a.m. without complaint or question. "I'm scared," I said. "I know. What if it's not enough? What if they look at me and see exactly what she's been saying I am?" Beverly was quiet for a moment. Then she said, "Julia, what would Robert have done?" I closed my eyes. "He would have made them prove it," I said. They said. "There you go," Beverly said quietly. "There you go." I didn't sleep that night, but in the morning, I got up and kept building. 4 days before the trial, Calvin called me at 7 a.m. "I need you to come in," he said. "Something's developed." The something was a man named Ray Tillman. Ray was 48, a former financial analyst who had worked for 3 years at the wealth management firm where Vanessa was a senior consultant. He had been terminated 8 months earlier, he told us, after raising questions about what he described as irregularities in client account management. He had filed an internal complaint. The complaint had been quietly buried, and shortly afterward he had been let go. He had been following the news of the civil case, he said. He'd seen my name in a brief article in the Atlanta Business Chronicle, and he had decided that what he knew was something I needed to hear. 4 years earlier, Ray told us, Vanessa had done this before. A client named Gerald Ashby, 79 years old, a retired schoolteacher, and I felt something move through me when Ray said that, who had come to the firm for help managing his late wife's estate. Over the course of 18 months, Vanessa had cultivated a relationship with him, positioned herself as an advisor with transfer authority, and moved $210,000 out of his accounts before his family noticed. The family had hired an attorney. The case had been settled out of court with a non-disclosure agreement. Vanessa had kept her license, kept her job, kept moving. "Is there documentation?" Calvin asked. Ray reached into the bag he'd brought with him and placed a folder on the conference table. "I made copies before they fired me," he said, "of everything I could get my hands on." Calvin opened the folder. I watched his face as he read. After a moment, he looked up at Ray. "There's an email here." "Page 11, Ray said. Calvin turned to page 11 and read aloud quietly. "Elderly clients are the easiest. They trust too much and remember too little." The three of us sat in silence for a moment. "That's her email address?" Calvin asked. "That's her email address," Ray confirmed. I looked at those words, written by the woman who had made me peach cobbler, who had called me Mom Julia, who had sat beside my husband's bed in his final weeks and held his hand, and I felt something clarify inside me. Not anger exactly, something cooler than anger, something that felt like the moment before a long overdue storm. "She's been doing this for years," I said. "At least once before," Calvin said carefully. "Possibly more." I nodded, looked at the folder, looked at Calvin. "Then I want to make sure," I said, "that she doesn't do it again." My alarm was set for 5:30. I was awake at 4:52. I lay in the dark for a few minutes, listening to the house, then got up and went to the kitchen and made coffee. Standing at the window while it brewed, I looked out at the backyard, at Robert's rose bushes, the ones he planted along the back fence 15 years ago. He tended them every spring, patient and meticulous, wearing those ridiculous canvas gloves he refused to replace until they literally fell apart. This past spring, no one had tended them. They had bloomed anyway. I thought about that while I drank my coffee. I chose my clothes carefully. The brown earth blazer that Robert always said made me look like a woman who knew exactly where she stood. The gold bead necklace he bought me for our 30th anniversary because he said every significant occasion deserved something that lasted. Low heels. Practical, because I intended to walk with steadiness, and I had no interest in performing for anyone. I drove to the courthouse alone. I had offers. Beverly had asked 3 times if she could come, and Calvin had offered to arrange a car. But I wanted those 40 minutes in the car by myself. I wanted to arrive having already done the hard internal work of the morning, so that when I walked into that building I was already settled. The Atlanta traffic was its usual dense and indifferent self. I drove through it and didn't listen to music and thought about Robert. About the note I had found in his nightstand drawer, the one I'd been carrying in my purse for 2 weeks. About Dorothy Simmons, who had agreed to testify. About Ray Tillman and his folder of documents. About the long, slow, invisible work of the past 8 months. They think I am confused, I thought. They have been saying it for so long, so consistently, with such practiced confidence that some days I had almost started to believe it myself. Almost. I pulled into the courthouse parking garage and found a space near the elevator. I sat in the car for a moment with the engine off. Then I gathered my purse, checked that the envelope was still safely inside it, and stepped out of the car. In the lobby of the courthouse, at the far end of the hall, Vanessa stood with Stuart Pratt and 2 associate attorneys, reviewing something on a tablet. She was already in her navy suit, already composed, already in position. She looked up as I approached from the opposite direction. Our eyes met. 3 seconds, maybe 4. She looked away first. I kept walking. Judge Owens called the room to order at 9:15, and Stuart Pratt rose from his chair like a man who had been waiting for this moment, the way other men wait for curtain call. He was good. I want to be honest about that, because the truth matters more to me than making myself look like I was never worried. Stuart Pratt was very good at what he did. He moved to the front of the courtroom with the unhurried confidence of someone who had stood in this exact spot, metaphorically speaking, hundreds of times before, and who had left most of those times having gotten what he came for. He began quietly, not with argument, not with accusation, with story. That was his first technique, and I recognized it immediately because I had used it myself for 28 years with rooms full of 10-year-olds. You don't lead with the lesson. You lead with the story that makes the lesson feel inevitable. His story went like this. A devoted couple, married more than 4 decades. A husband, a good man, a hard-working man, who received a devastating diagnosis and spent his final months thinking not only about his own comfort, but about the welfare of the wife he was leaving behind. A husband who, in those final weeks, had difficult but necessary conversations about the future, who made careful, loving arrangements, who trusted his son and daughter-in-law to carry out his wishes with care and integrity. And then, a widow, grief-stricken. Pratt used that word with practiced gentleness, like a man laying flowers, confused by loss, struggling with the complexities of a substantial estate, misinterpreting legal documents she didn't fully understand, and ultimately, tragically, directing her pain at the very people who had only ever tried to help her. He used the word confused twice. The first time I kept my eyes on the middle distance and breathed slowly through my nose. The second time I felt Calvin's pen stop moving beside me, just for a half second, and then resume. He had noticed too. Pratt concluded his opening by describing Vanessa as a dedicated daughter-in-law who had sacrificed her own time and energy to support an aging, grieving woman through an impossibly difficult period, and who was now, through no fault of her own, being dragged through a public legal proceeding because that woman's grief had curdled into something that looked, regrettably, like accusation. He said the word aging once. He sat down. I looked at my hands on the table. Flat. Still. I thought about Robert's rose bushes blooming without anyone to tend them, and I thought, they have been saying this about me for over a year. They have been practicing this story for months. And none of it, not one word of it, is true. I thought, good. Let them finish. Calvin's opening was shorter. He didn't tell a story. He listed facts, dates, amounts, document numbers, in the measured, even tone of a man reading a balance sheet. He said that the evidence would show that the power of attorney at the center of this case bore a forged signature, that the psychological evaluation introduced to challenge Julia Harmon's competency had been conducted without her knowledge or consent by a doctor paid by the opposing party, that the defendant had done something very similar to another vulnerable person 4 years earlier. He said, "The story you just heard is designed to make you feel sympathy for the defendant. The evidence is designed to make you understand what actually happened. My job today is simply to make sure you see the difference. He sat down. Judge Owens looked at Pratt's table. You may call your first witness. The first witness for the defense was Dr. Leonard Ferris. He was 60, with a trim gray beard and the kind of deliberate, unhurried delivery that is either a sign of deep intelligence or a very effective imitation of it. He settled into the witness stand with the ease of a man who had testified before and knew how to make a courtroom feel like his natural habitat. He wore a blue tie. He kept his hands folded in his lap. Pratt walked him through his credentials first. Medical degree, residency, 20 years in private psychiatric practice. Board certifications, publications. It took 7 minutes and was clearly designed to. By the time Pratt asked his first substantive question, the jury had been given 7 minutes to decide that this was a serious, credible man whose opinions deserved serious, credible weight. Then Pratt asked him about me. Dr. Ferris explained that he had been engaged. He used that word, engaged, as if he were describing a business arrangement, which I supposed he was, to conduct a cognitive assessment of Julia Harmon in the fall of the prior year. He described the assessment methodology in technical language that I could see the jury working to follow. He talked about memory recall tests, executive function indicators, behavioral observation protocols. Then Pratt asked him for his conclusions. In my professional opinion, Dr. Ferris said, Mrs. Harmon showed evidence of moderate short-term memory inconsistencies and some difficulty with complex sequential reasoning, particularly as it relates to financial decision-making. These findings are consistent with early-stage cognitive decline. I heard someone in the gallery shift in their seat. I looked straight ahead. My hands were flat on the table. Calvin rose for cross-examination. He started slowly, almost conversationally. The way he always started, I had come to understand, when he intended to end somewhere very different. Dr. Ferris, you described this as a cognitive assessment. Can you walk us through the standard protocol for a formal cognitive assessment? Ferris did. Calvin listened attentively, nodding. And in a standard assessment of this kind, would it be typical for the subject to be present? To actively participate? Yes. Typically the subject would. Mrs. Harmon was not present during your assessment, is that correct? A brief pause. The assessment was conducted through observational. Yes or no, doctor? Was Mrs. Harmon present? She was not physically present, no. She was not interviewed? Not directly, no. She was not given any standardized tests? The protocol used was, Doctor. Calvin's voice was patient, almost kind. Did Julia Harmon take a single standardized cognitive test as part of your assessment? Ferris adjusted his position slightly. Not in the traditional sense. So your conclusion, the one you just presented to this jury as your professional opinion, was based on observational reports provided to you by the party who hired you about a woman you never met, never interviewed, and never tested. Silence. That is not an inaccurate characterization, Ferris said carefully. Thank you, Calvin said. One more question. Who paid for this assessment? The pause was longer this time. I was retained by the Whitfield legal team. The same legal team representing Vanessa Harmon. Yes. Thank you, doctor. Calvin sat down. It was effective. The jury had noticed. I could see it in the slight recalibration happening in several faces, the barely perceptible shift from this is credible to I'm not sure what this is. But it wasn't enough to win anything. It was enough to plant doubt, which was its purpose. The second witness was a woman named Sandra Polk, who lived 2 streets over from the house Robert and I had owned for 30 years. She was about 70, nervous in the witness stand, plucking at the hem of her jacket. I recognized her. We had waved to each other across lawns for years, exchanged pleasantries at the neighborhood 4th of July gathering. Nothing more than that. She told the jury that she had seen me in my driveway one morning, walking in what she described as an aimless, uncertain way, looking as though I didn't know where I was going. She said I seemed not quite right. Calvin's cross-examination was brief. Mrs. Polk, what date did this occur? She couldn't say exactly. What time of day? Morning, she thought. Early. Did you speak to Mrs. Harmon? No, she had just observed from her car. So you don't know whether Mrs. Harmon had just received difficult news, whether she'd had a poor night's sleep, whether she had simply stepped outside to get the newspaper and paused to look at the sky. I just know what I saw. And what you saw, Calvin said, was a woman standing in her own driveway, on an unspecified morning, for an unspecified length of time. He let that sit for a moment, then, nothing further. The cross-examination was effective. But I was watching the jury, and I knew that Sandra Polk's testimony had done something that was harder to neutralize than expert credentials or precise methodology. She had given the jury a picture, a vague, subjective, impossible-to-disprove picture of an old woman wandering in a driveway. And pictures have a way of persisting even after you've been told they're out of focus. I kept my face still. Let them finish, I thought again. It's not their last word, and it's not mine. The recess was called at 12:20. Calvin and I went to a small conference room down the hall from the courtroom. Beige walls, a rectangular table with a water pitcher in the center. The particular institutional quietness of rooms that exist only to be used between more important things happening elsewhere. Calvin poured us each a glass of water and sat down across from me. He didn't speak for a moment, which was something I appreciated about him. He never filled silence just to fill it. "How are you reading the jury?" I asked. He tilted his head slightly. "Pratt moved them in the morning. Ferris lost some of what Pratt built. Polk gave them an image that's going to sit in their heads." He paused. "We need this afternoon to be clean." "It will be," I said. He looked at me over his glasses. "Dorothy knows what she's walking into?" "Dorothy has been ready for 3 weeks. She's been ready longer than that, honestly. She just didn't have anywhere to go with it." Calvin nodded slowly. "And Ray?" "Ray wants this," I said. "He's been waiting for it." We were quiet for a moment. Then Calvin said, "And you?" I looked at him. "When Pratt gets you on the stand," Calvin said carefully, "he is going to try to make you angry. He's going to try to make you seem defensive, flustered, emotional, everything he needs to make his story feel true." He held my gaze. "I need you to be the most patient person in that room." "Calvin," I said, "I taught 5th grade for 28 years. I once spent 45 minutes calmly explaining long division to a child who had already thrown his worksheet on the floor twice and bitten another student. I know how to be patient." The corner of Calvin's mouth moved. "Good." I reached into my purse and took out the envelope. I placed it on the table between us. It was a plain white envelope, slightly soft with handling, the kind that comes in bulk boxes from an office supply store. Robert's handwriting was on the front. Not my name, just a note to himself, the kind of shorthand he used for things he wanted to remember. "Dr. Morrison, important. Do not forget." I had found it in the nightstand drawer on his side of the bed. The drawer I hadn't opened in 8 months because every time I reached for the handle, I felt the specific weight of everything it contained. His reading glasses case, his small Bible with the cracked spine, his watch that had stopped and that I hadn't wound because winding it felt like something I wasn't ready to do. 2 weeks before the trial, I had opened the drawer. The envelope was near the back. Inside was a single piece of paper, handwritten, dated October 7th, 2 days before the date on Vanessa's forged power of attorney. Robert's handwriting, unmistakably his, slightly more labored than it used to be, but absolutely legible. "Dr. Morrison, please make sure that Julia is present and in agreement for any legal documents going forward. She needs to know about everything. This is important to me. R.H." He had known something was wrong. He hadn't known exactly what, but he had felt it. The way you feel something approaching before you can name it. And he had written this note, quietly, in his careful engineer's hand, and tucked it in the drawer. Like a man who latches the gate before he goes to sleep, not because he knows a storm is coming, but because he believes in being ready. Calvin looked at the note for a long time without speaking. Then he looked up at me. "He was protecting you," he said. "He always was," I said. "Even at the end, even when he was too tired to do much else." Calvin carefully placed the note back in its envelope and slid it across the table to me. "Keep it in your hand when you come back in," he said. "Don't put it down." I picked it up, held it. The afternoon light through the conference room's single window had shifted while we sat there, moving from gray to something thinner and more determined. The kind of light that comes through when clouds begin to break. "Ready?" Calvin asked. I put the envelope back in my purse, right at the top where I could reach it without looking. "Let's go back in," I said. The afternoon session began at 1:45. Calvin called his first witness, and I watched Stuart Pratt's face as Dorothy Simmons made her way down the center aisle of the courtroom. He wasn't worried. I could see it. The particular quality of attention a confident man pays to something he doesn't consider a threat. Dorothy was 78 years old, moving with the careful deliberateness of someone who had learned to negotiate the world with a walker, wearing a floral dress in yellow and cream that belonged more properly at a Sunday morning service than a civil proceeding. Her white hair was pinned back neatly. She wore small pearl earrings. She looked, I imagined, exactly like what Stuart Pratt expected her to look like. An old woman, soft around the edges, the kind of witness whose testimony could be gently dismantled and set aside. He would spend the next 20 minutes revising that assessment. Dorothy settled into the witness stand with a patience that I recognized as its own kind of confidence. The patience of someone who is not performing steadiness because they have no need to perform it. Calvin walked her through the preliminaries. Her name, her age, her address, her relationship to the Harmon family. 22 years as a neighbor. The kind of neighbor who kept a spare key and knew which nights the trash cans needed to go out because the family was traveling. Then Calvin asked her about October 9th. Dorothy folded her hands in her lap and spoke in the clear, measured voice of a woman who had been a third-grade teacher for 31 years and knew exactly how to make sure an audience understood every word. She told the court that on the morning of October 9th, she had arrived at the Harmon house at approximately 10 o'clock, at Julia's request, to sit with Robert while Julia attended a routine medical appointment of her own. She had done this several times during Robert's illness. It was simply what neighbors did, she said, when neighbors were the right kind. She described Robert's condition that morning. He had been awake when she arrived, but very weak. The home health aide had already been in and gone. Robert was in the hospital bed that had been set up in the downstairs bedroom, propped against pillows, with a morphine drip managing his pain. His hands, Dorothy said, had been trembling badly that day, worse than she'd seen before. At one point, he had asked her to open his medication bottle for him because he couldn't manage the child-proof cap himself. Could he have held a pen? Calvin asked. Dorothy looked at him steadily. He could not have held a pen with any control that morning. He could barely hold my hand. The room was quiet. Calvin let the quiet sit for a moment, then asked Dorothy if she had anything that could corroborate her account of that day. Dorothy reached into the large fabric tote bag she'd carried to the stand and produced, first a small spiral-bound notebook, the kind sold at drugstores for $2, the kind that lasts for years when you write in it faithfully. She held it up. "I have kept a daily diary since 1987, she said, with a composure that suggested she was aware of the effect this was having. "I write something every evening before bed. Not much, just the important parts of the day." She opened the notebook to a marked page and read aloud, in that same measured classroom voice. October 9th. Sat with Robert this morning while Julia went to her appointment. He was having a hard day. Hands shaking badly. Couldn't open his pill bottle. I had to do it. He slept most of the time I was there. Took a photo to send to Julia so she could see he was resting peacefully. Home by 2. She closed the notebook. Then she reached back into her tote bag and produced her phone, a slightly older model in a bright blue case, and handed it to Calvin, who had already arranged with the court to have its contents displayed on the evidence screen. The photograph appeared on the screen. Robert, in his hospital bed, eyes closed, hands visible on top of the white blanket. Hands that even in the stillness of a photograph showed the slight contracture, the helpless curl of fingers that could not grip. The timestamp in the corner of the image read, October 9th, 11:47 a.m., the same date as the power of attorney, the same morning. I looked at that photograph of my husband and I felt something move through me that was not grief exactly. Grief I had been living with for months. Grief had become as familiar as furniture. But something adjacent to it. Something that was about the specific cruelty of what had been done. Someone had looked at this man. This man who could not open his own pill bottle, who could not hold his neighbor's hand without trembling, and had decided he was still useful, had decided that his name, even at the end, even in those last quiet days, could be taken and used and forged onto a document that would serve someone else's purposes. I pressed my hands flat on the table. Calvin turned to Pratt. "Your witness." Pratt approached the stand with the careful energy of a man recalibrating in real time. "Mrs. Simmons," he said with a smile that was nearly warm, "you've been a neighbor to the Harmon family for a long time." 22 years, Dorothy confirmed pleasantly. "You were close to them." "I was." "And you'd like to help Mrs. Harmon." Dorothy looked at him, not unkindly, but with the clarity of a woman who had spent 3 decades identifying when a child was trying to lead her somewhere. "I'd like to tell the truth," she said. If that helps Mrs. Harmon, it's because the truth tends to do that. Pratt pressed on, trying to establish uncertainty about the date, about her memory, about the reliability of a diary kept by a 78-year-old woman. Dorothy answered each question with the same unhurried precision. When he suggested that her recollection might be influenced by her relationship with Julia, she tilted her head slightly and said, "Mr. Pratt, I'm 78 years old. I was a teacher for 31 years. I have been writing in a diary every single evening since Ronald Reagan was in his second term. I know what day it was, and I know what I saw." Pratt had no further questions. As Dorothy made her careful way back down the aisle, she passed my table, and our eyes met briefly. She gave me a single small nod, the nod of one former teacher to another, and continued on to her seat. Calvin called Ray Tillman next. Ray was not what the courtroom expected, I think, after Dorothy. He was 48, medium height, in a plain white Oxford shirt and dark slacks. No tie, no blazer. He had the slightly worn look of a man who had been carrying something heavy for a long time and was about to set it down. He sat in the witness stand without fidgeting and answered Calvin's preliminary questions in a straightforward, factual way. I watched Vanessa when Ray walked in. She recognized him. I saw it, a fractional tension across her shoulders, a slight forward shift in her posture, immediately corrected. Then the careful stillness returned. But it had been there. Pratt noticed it too. I saw him lean slightly toward her and say something quietly, to which she gave the smallest shake of her head. Calvin established Ray's background, his position at the wealth management firm, his tenure, his role, his termination, and the circumstances surrounding it. Then he asked Ray to describe what he had witnessed during his time at the company as it related to Vanessa Harmon. Ray testified clearly and without embellishment. He described Gerald Ashby, 79 years old, a retired educator, widowed, who had come to the firm seeking help managing his late wife's estate. He described watching Vanessa cultivate that relationship over 18 months, making herself indispensable, positioning herself as the person Mr. Ashby trusted most. He described the point at which he had noticed the transfer authority being added to Mr. Ashby's accounts. He described the transactions he had flagged, the internal complaint he had filed, and the response he had received. Silence, followed by termination. "Did Mr. Ashby's family take legal action?" Calvin asked. "They filed a civil complaint. It was settled with a non-disclosure agreement before it reached court." "And to your knowledge, were there professional consequences for Ms. Harmon?" "None." Calvin walked to the evidence table and picked up a document. "I'm entering into Evidence Exhibit 14, a copy of an internal email sent from Vanessa Harmon's firm account on March 3rd, 4 years ago, to a colleague." He read it into the record. "Elderly clients are the easiest. They trust too much and remember too little." The room did not erupt. It did something more unsettling than erupt. It went very, very quiet, the way a room goes quiet when something has been said that cannot be unsaid, that is already in the process of rearranging everything around it. I did not look at Vanessa. I looked at the jury. Juror number 4, the woman in her early 50s, third seat from the left in the front row, who had been attentive all day but whose expression had remained carefully neutral, was looking at the email on the evidence screen. As I watched, she pressed her lips together in a line so slight it was barely visible. But I saw it. 28 years of watching children's faces had given me a precise and reliable ability to read the moment when understanding arrives. It had arrived. Pratt's cross-examination of Ray was aggressive in a way that his earlier cross-examinations had not been. He challenged Ray's motivations, a disgruntled former employee with an axe to grind. He challenged the provenance of the documents, obtained improperly, possibly illegally. He challenged the email's context, taken out of a larger conversation, meaning distorted. Ray answered each challenge with the same calm, factual steadiness he'd maintained throughout. When Pratt suggested he was motivated by personal grievance, Ray said simply, "I was motivated by the fact that I watched someone do to Julia Harmon what I watched them do to Gerald Ashby, and I decided I wasn't going to stay quiet about it twice." Pratt had no further questions. I looked at Derek as Ray stepped down. My son was staring at the table in front of him. His jaw was set in the way it had been since he was a teenager working through something difficult, a particular kind of stillness that meant he was not calm, but was refusing to not be calm. Then, slowly, he raised his eyes. He looked at Vanessa. She was looking straight ahead. She did not look back at him. He kept looking at her for a long moment. Then he looked at me. I held his gaze. I didn't nod, didn't smile, didn't signal anything. I just let him look. Then I turned back to the front of the room because there was still work to do. Calvin called me at 3:20 in the afternoon. I rose from my chair, smoothed my blazer, and walked to the witness stand. I settled into the seat, placed my hands in my lap, and looked out at the room. From the witness stand, the courtroom looks different than it does from the table. You can see more faces. The jury becomes less of a collective and more of a collection of individual people, each one with a specific expression, a specific quality of attention. I had spent my career reading rooms full of faces, calibrating what was landing and what was not, adjusting in real time. I looked at those faces and felt the particular steadiness that comes not from the absence of fear, but from having decided, a long time ago, that the truth was worth more than the comfort of staying quiet. Calvin took me through the foundational testimony efficiently. My marriage, Robert's illness, the discovery of the bank letter, the forged signature, the meeting with Vanessa at the coffee shop. I answered every question in the same even, direct voice, not performing calm, simply being it, because I had been preparing for this moment for 8 months, and I was not going to waste it. Then Calvin asked me about the note. I reached into my jacket pocket. I had moved it there from my purse at the lunch break so I wouldn't have to reach down, and I held up the envelope. "Can you describe what that is?" Calvin asked. "This is a note written by my husband, Robert Allen Harmon, in his own hand, dated October 7th of last year, 2 days before the date on the power of attorney that has been presented to this court as bearing his signature." Calvin had the note entered into evidence and displayed on the screen. "Can you read it for the court?" I looked at Robert's handwriting on the screen. I had read it perhaps 40 times in the past 2 weeks. I had read it the first time sitting on the edge of our bed at 11 o'clock at night, with shaking hands, and then sat very still for a long while, feeling something that I can only describe as the specific peace of being known. I read it aloud in the same steady voice I had used for everything else. "Dr. Morrison, please make sure that Julia is present and in agreement for any legal documents going forward. She needs to know about everything. This is important to me. R.H." The room was quiet. Calvin said, "In your understanding, what was your husband communicating in this note? That he wanted me involved in any legal decisions, that he trusted me, that he was asking his doctor, in writing, because Robert was an engineer and believed in putting important things in writing, to make sure that I was not excluded. Did he express any concerns to you during his illness about your ability to manage finances or make decisions?" "Never, not once, not in 42 years. Calvin nodded. "Thank you, Julia. Nothing further." Pratt rose. He began, as Calvin had predicted, gently, almost sympathetically. He expressed condolences for my loss, formally, carefully, in a way designed to establish him as a reasonable man before he began to be unreasonable. He asked about the strains of caregiving, about the emotional weight of watching a spouse decline, about the ways grief could affect perception and memory. I answered every question, directly, briefly, without elaboration he hadn't asked for. He moved to specific incidents, the ones Vanessa had cultivated through months of careful observation. A missed appointment, a confusion about a date, a moment Sandra Polk had observed from her car window. He presented each one with the patient accumulation of a man building a wall, one brick at a time. I addressed each one. I did not rush. I did not qualify excessively. I did not grow defensive. I simply answered. Then Pratt paused, shuffled a paper, looked at the jury for just a moment before looking back at me, and he asked the question I had known was coming since the day Calvin and I had first mapped the terrain of this case. "Mrs. Harmon, you've described yourself today as a meticulous, organized woman, someone who was closely involved in the management of your household finances for 42 years, someone who would immediately recognize an anomaly in your bank accounts." He paused, then explained to this court why it took you more than 8 months after your husband's death to discover that nearly $900,000 of your estate had been transferred or encumbered. If you were as attentive as you claim, how did you miss it for that long? He said it with the tone of a man who believed this was the question that ended things, the question that made everything else irrelevant. That took every piece of testimony from the morning and afternoon and collapsed it back into the simplest version of his story. A confused woman, too lost in her grief to know what was happening around her. I looked at him. I did not answer immediately. Not because I didn't know what to say, but because I had learned, in 28 years of teaching, that the most important answers deserve a breath of space before them, that the words you most need people to hear should not be rushed into the room, but walked in quietly, so everyone has time to make space for them. I looked at Pratt. Then I looked at the jury. Then I folded my hands on the railing of the witness stand, and I spoke. Because I was sitting next to my husband's bed every day for 8 months. I was counting his breaths. I was managing his medications and tracking his pain levels and calling his doctors and washing his face and reading to him when he couldn't sleep and holding his hand when the nights were bad and singing to him. Because music helped at the end, more than almost anything else. I was doing what a wife does for the man she has loved for 42 years when he is leaving the world, and she is trying to make sure he doesn't leave it alone. I kept my voice even. Not flat, even. There is a difference. I did not read my bank statements on time. I did not review my investment accounts on schedule. I did not catch, in those 8 months, what someone who had access to my financial institutions was quietly doing in the background. I paused once more. I am sorry that my devotion to my dying husband made me a more convenient target. I am sorry that I was too busy loving him to notice in time. But I want to be very clear about something. I looked directly at Stuart Pratt. Not noticing something is not the same as being confused, and being a devoted wife is not the same as being incompetent. I would like this court to remember the difference. The room was silent. Not the silence of a room waiting for what comes next. The silence of a room that has just received something and is still in the process of taking it in. Juror number 4 had her head slightly bowed. The man in juror seat 7, broad-shouldered, perhaps 60, who had maintained a careful impassivity all day, was looking at me with an expression that was no longer impassive. Stuart Pratt stood at his podium for a moment. Then he said quietly, "Nothing further." I descended from the witness stand. I walked back to my table. I did not look at Vanessa. I did not look at Derek. I sat down, placed my hands flat on the table, and looked straight ahead. Calvin leaned slightly toward me and said nothing at all. He didn't need to. The jury began deliberating at 4:35 in the afternoon. Calvin and I went to the sandwich shop 2 blocks from the courthouse. He ordered coffee. I ordered tea and did not drink it. We sat across from each other in a window booth and watched the Atlanta afternoon outside. People moving past on the sidewalk with the ordinary purposefulness of people who were not waiting for a verdict, who had other things on their minds, who did not know that in a room 2 blocks away, 12 people were sitting with a piece of my life in their hands. We didn't talk much. Calvin checked his phone periodically. I looked out the window. At some point, I thought about Robert sitting at our kitchen table with his yellow legal pad, working through the numbers with his careful engineer's patience, building something slow and real. I thought about the rose bushes blooming without anyone to tend them. I thought about Dorothy Simmons and her drugstore diary and 31 years of third-grade classrooms. I thought about Ray Tillman deciding, the second time around, that he was not going to stay quiet. I thought about the note in the envelope. She needs to know about everything. This is important to me. I know, Robert, I thought. I know. Calvin's phone buzzed at 4:47. He read the screen and looked up at me. "They're back," he said. 6 hours and 12 minutes. In my limited experience of such things, Calvin had told me that was neither short nor long. It was the length of a jury that had taken it seriously and reached a conclusion they could stand behind. We walked back in the fading afternoon light, and I thought about nothing in particular, which I think is what the mind does when it has arrived at the outer edge of what it can prepare for. Judge Owens read the verdict herself, in the same measured tone she had maintained throughout the entire proceedings, a voice that neither dramatized nor diminished, that simply said the thing directly, which I found in that moment to be the most merciful approach possible. The power of attorney dated October 9th, void. The court found insufficient evidence that Robert Allen Harmon had possessed the physical or cognitive capacity to execute a legal document on that date, and substantial evidence that the signature had been falsified. The transfer of $340,000 from the joint Harmon account, to be reversed and restored in full, with interest calculated from the date of transfer. The home equity refinancing of $280,000, the instrument declared void, the encumbrance to be removed from the property title. 3 of the investment account modifications, reversed. Vanessa Lee Harmon, her case file to be referred to the Fulton County District Attorney's Office for investigation of document fraud, elder financial exploitation, and conspiracy. Attorney Stuart Pratt and the firm of Whitfield and Pratt referred to the State Bar of Georgia for disciplinary review. Judge Owens set down the papers and looked at the room over her reading glasses for a moment. She didn't say anything beyond the formal language of the verdict. She didn't need to. I sat with my eyes closed through most of it, not because I was overwhelmed, though I was, in ways I am still finding words for, but because I wanted to hear each word cleanly, without the distraction of the room around me. I wanted to receive it properly, the way you receive something you have worked a long time toward. When it was over, I opened my eyes. Across the room, Vanessa sat with her hands in her lap, very still, in a posture that was no longer composed so much as simply empty, the stillness of someone whose performance has ended and who has not yet decided what comes next. Pratt was already moving, gathering papers, speaking quietly to his associate in a voice I couldn't hear. Derek was looking at the table. His father's hands were flat on the surface. Still, Calvin touched my arm briefly, a small, quiet gesture. That was all. I sat in my car for the long time. The courthouse parking garage in the early evening had a specific quality of quiet. The sounds of the city muffled by concrete, the occasional distant echo of a door or an engine, the particular loneliness of a large structure with very few people in it. The overhead lights had come on, casting that familiar institutional glow that flattered nothing and hid nothing. I sat with my hands in my lap and my purse on the passenger seat, and I didn't move for several minutes. I wasn't crying. I wasn't doing much of anything. I was simply sitting inside what had just happened, the way you sit inside a room for a moment after you've rearranged it, taking in the new shape of things. I picked up my phone. Beverly picked up on the second ring. "Julia." "It's over, Bev." There was a pause on the line. Then I heard it. Not crying exactly, but the sound of someone exhaling something they have been holding for a very long time, a breath that releases more than air. "Tell me," she said. "We won," I said. "All of it." Beverly made a sound that I will not try to describe precisely, because some sounds are not meant to be translated into other forms. I sat in the parking garage and listened to my oldest friend respond to the news, and I felt something settle in my chest that had not been settled in 14 months. The elevator across from where I was parked opened, and Vanessa came out, flanked by Pratt and his associate. She was moving differently than she had that morning. The precision was gone, replaced by something smaller and more directed inward, the walk of someone navigating from one moment to the next without a larger plan. Pratt was still talking, professionally, damage managing. She wasn't listening. I could see that from where I sat. Derek came out a few steps behind them. He stopped when he saw my car. He stood there for a moment. Vanessa kept walking, didn't notice or didn't turn. Pratt's voice continued somewhere behind Derek, not noticing or not caring that one of the party had stopped. Derek walked to my car. He stood outside the driver's side window. I could see him clearly. My son, 34 years old, with his father's hands and the exhausted, hollow-eyed look of a man who had spent a day watching something he thought was solid turn out to be paper. He raised his right hand and placed it flat against the window glass. A gesture without words. The only gesture, perhaps, that was honest enough for that moment. Not an apology, not an explanation, not a request for anything. Just a hand on glass. Just I am here. I know what happened. I don't have words yet. I looked at him for a long moment. Then I raised my left hand and placed it on the inside of the window, palm against palm, glass between us. We stayed like that for perhaps 5 seconds. Then I started the car. He stepped back. I pulled out of the space and drove toward the exit, and I did not look in the rearview mirror, because I had learned over the past 14 months the importance of facing the direction you are going. There was no single moment when everything became all right. That is not how things become all right. It happens the way Robert's rose bushes bloom, without announcement, incrementally, in a way you notice only when you step back and look at the whole. Vanessa was formally charged by the district attorney's office 6 weeks after the civil verdict. The charges included document fraud, elder financial exploitation, and conspiracy. The Ashby case, reopened at the DA's discretion in light of new evidence, became part of the broader investigation. The non-disclosure agreement from the Ashby settlement was challenged and ultimately voided. Gerald Ashby's family received a call from an attorney they had never expected to hear from again. Pratt's firm was suspended from practice pending the state bar investigation. I did not follow the details closely. I had other things to tend to. Derek filed for divorce 3 weeks after the verdict. He called me once during that period, a voicemail left late at night, in the slightly rough voice of someone who had been sitting alone with difficult thoughts for hours. He said, "Mom, I know I don't have the right to ask for anything right now. I just need you to know that I'm sorry. Not the way people say it when they want something to change. Just sorry, that's all." I listened to the message 4 times. I didn't call back that week, or the next, but I didn't delete the message either, and eventually, on a Sunday afternoon in early spring, I called him back, and we talked for 40 minutes about nothing important: his new apartment, my garden, a book he'd been reading, and it was stilted and careful, and not yet what it would someday be. But it was a beginning. Beginnings do not have to be graceful to be real. Ray Tillman sent me a text message the week after the verdict. "Thank you for not settling." 4 words. I read them standing in my kitchen and thought about all the times, in the months of preparation, when settling had seemed like the reasonable choice. The safe choice. The choice that cost less. I thought about what settling would have cost instead. I used part of the restored funds to pay off the remaining balance on the Decatur house. The home Robert and I had lived in for 30 years was fully, unambiguously, legally mine. I had the deed framed, not to hang on a wall, but because I wanted to hold it in my hands once and feel its specific weight. I went back to teaching, not to King Elementary. I was retired from that, and retirement has its own dignity that I wasn't interested in walking backward from. I went to the Jefferson Community Library on Tuesday and Thursday mornings, where I ran a literacy class for adults. No salary. A small room with fluorescent lights and mismatched chairs and a whiteboard with a slightly dried-out marker. And on my table, in a small ceramic bowl, peppermint candies. Robert would have liked that. It is a Tuesday morning in April, and I am sitting on my back porch with a cup of coffee, watching what is happening along the back fence. The roses are coming in again. Pale pink ones first, the way they always do, with the yellow ones coming later, and the deep red ones that Robert said were his favorites, saving themselves for last. He planted them 15 years ago, chose each variety with the same patience he brought to every project, researching, comparing, deciding slowly, and then committing fully. He tended them every spring and said very little about them, because Robert was not a man who required acknowledgement for the things he did with care. They bloomed when he was alive. They bloomed the year he died, with no one to tend them. They are blooming now. I think about what the past 14 months have asked of me, about the specific education of discovering that someone you trusted was, beneath the surface of every smile and every warm embrace, calculating. About the particular loneliness of fighting for something that everyone around you is suggesting you let go of. About the long, slow, unglamorous work of gathering evidence, receipt by receipt, document by document, memory by memory, in the service of a truth that had no advocate except you. I think about Dorothy Simmons and her $2 diary, about Ray Tillman deciding the second time to be the person he wished he'd been the first time, about Calvin Reeves in his small office with his unremarkable furniture, opening a folder and asking how much time I had. I think about Robert, always Robert, writing his careful note in the nightstand drawer, asking that I be included, that I be informed, that I be treated as the partner I had always been. Not because he knew exactly what was coming, but because he was an engineer. And engineers, Robert always said, don't leave important things to chance. He built something. He built it slowly, quietly, without fanfare, over 40 years. And when someone tried to take it by convincing the world that the woman he had loved for 42 years was too confused, too fragile, too diminished to know what was hers, the thing he had built was still there. The house stood, the truth stood, I stood. They said I was a confused old woman who didn't understand her own finances. They said it for long enough, and with enough preparation and enough documentation manufactured from thin air, that some days, I will be honest with you, I had come close to wondering if it was true, close to wondering if grief had unmade something in me that I couldn't see. That is what sustained, deliberate, well-resourced gaslighting does. That is what it is designed to do. But Robert's signature was not his signature. I knew it then, I know it now, and I knew my own mind. That in the end was the thing they could not take, because it was the thing they could not reach. You asked me once, through the screen, what you would have done in my place. I don't know what you would have done. I only know what I did. I showed up. I built my case. I did not settle for 14 cents on the dollar of what was mine. I sat on that witness stand and I told the truth in a plain, clear voice, and I trusted that truth was enough, because I had spent 28 years teaching children that it was. It was enough. To every woman who has ever been told she is too old, too emotional, too grief-stricken, too confused to trust her own understanding of her own life, to every woman who has ever stood in a kitchen holding a letter that made no sense and felt the floor shift beneath her, to every woman who has ever been smiled at by someone who was building a case against her with the other hand, I want you to know something. Your signature is your signature. Your mind is your mind. Your life is your life. Make them prove otherwise.